Welcome, ladies and gentlemen. We are here for a public dialogue on the Milo land question, organized by the Department of Geomatics and Land Management, Makerere University. In this public dialogue, we're here to talk about the everything Milo land. One of the things that has come up continually is the discussion around the overlapping land rights for the tenants and the landlords on Milo land. So we're here to break down these overlapping land rights, and we're here to also look at the challenges, but the possible solutions to the challenges that exist on this tenure type. The department that is running this dialogue is having a conference under the theme Geomatics, Resources, Response, and Resilience in the context of emergency. One of the things that we have to emphasize here is the fact that there's been a lot of debate around Milo land. So this public dialogue is aimed at having a discussion of, one, the legal and also the other understanding of Mailo Land Tenure as a system of land holding, but also to have a discussion around what it is that is in the social domain, especially around the relations on this land. So today we're going to be looking at the two aspects of it, the legal, the bit of the administration, but also the relations on the land. With me is a distinguished panel of people from the academia, but also from the kingdom. We're going to have people online. So we welcome the people that are online. Two things that we need to do on the administrative side. One is that please, when you join, mute your microphone so that we don't have the interferences that come with the different sounds that come from your side. But two, because we are going to be, one, this side physically, but also virtually, we may not have the opportunity to speak to you. So all the questions and concerns that you have, please put them in the chat window. We're going to have an opportunity to read off the chat window, all your questions and the comments. So please put your questions there and your comments, and we'll be able to interact with you. At any point that we feel that we must take calls, we will do exactly that. So thank you so much for logging in. Thank you so much for being a part of this. And for those of you that we have here, the students from SEDAT, please welcome, and we're glad to have you here. To the panelists, we're really glad to have you, and we're really glad that you've made time to have this discussion. We're going to go one by one, so we may not have to make an introduction of all the panelists, but at every point that you have to make your presentation, we'll have the opportunity to know who you are and also what it is you have to contribute to this discussion. And I hope that is agreeable to all of us. So please, welcome to this meeting. Whenever a discussion on Milo land comes up, there is something called the historical injustice. We're not very certain lately where the injustice has gotten to, because then there's been evolution of this kind of tenure right from the 1900s, where they talk about the start of the injustice. So where are we at now, many decades later? We need to have an understanding of that perspective of the Milo land allocation and registration process. And to actually understand, was there a historical injustice? How is it still playing out in the current times? With me to discuss that is Ms. Sarah Kulata, who's a land tenure and legal expert and formerly with the Ministry of Lands, Housing, and Urban Development. Please welcome Ms. Sarah Kulata.
Thank you very much. Was there a historical injustice? In order to understand whether there was a historical injustice, you have to know a little about what was there before and then what was there after the Milo land introduction. Before Milo land introduction came, We had land holding here in Uganda, but because Milo land is mainly in Uganda, I will dwell in Uganda. Uganda, we had 3 methods of land holding. At that time, we had the Butaka holding, the Butongole holding, and Owesengeze land holding. The Baganda were an organized society before 1900, and they were organized around clans. And clans settled around hilltops and in the fertile valleys. And they would have a head of clan. This head of clan was the Mutaka. And the land so occupied by a particular clan was the Butaka land. So the head of clan was chosen by the clan members, and the Mutaka would control that land. Over time, society evolved, and these clans also had a head, the Sabataka, who would also have a say in appointing, in electing, appointing the Mutaka. But some friction came in because the Sabataka didn't have all the say. So the clans, the society evolved. The Kabaka, the Mutaka, the Sabataka, not the Mutaka, the Sabataka, now appointed the Mutaka, but also had an administrative setup, the Bakungu and the Batongole. The Bakungu were the head chiefs, and the Batongole were the lesser chiefs. These Bakungu and Batongole also had land allocated to them by the Kabaka for purposes of handling administrative duties. And this land, by and large, came to be known as Butongole land. So Butaka land was by the clans and Batongole by the chiefs. Why do we call it Mailo land? Because it was given out in square miles. And the Batongole and the Bakungu were the major benefits. They got land in their official capacity in square miles, and they also got land in their private capacity in square miles. You imagine a person getting 16 square miles, and then this person's land had to be confirmed by the Luchiko. And the Luchiko was composed of this very Bakungu. So you know, they had to first confirm themselves before they think of others. So they confirmed their locations. From 1900 to 1905, they were making this list, confirming themselves first, and then the lesser chiefs, and then others. All in all, over 8,000 square miles were allocated in Milo land. After allocation, no concern was made of the Butaka land. An allocatee would decide where he wants. Imagine somebody being in Chagwe and allocated 16 square miles. He could pick maybe 3 in Chagwe, go to Buddu, pick 2, go to Bugangaizi, pick 2, go to Bulemezi, pick another 2, until he got the 16 square miles. And after picking where he or she wanted, mainly they were his, because the only she's who got were the Nalinyas. After picking what he wanted, then the Luchiko would confirm that land, and then the Luchiko would issue what we call a provisional certificate. This provisional certificate was supposed to be taken to the land office, and once confirmed by a boundary survey, then a final certificate would be issued. We always hear of PC and FC. These were the first document of registration of Milo land. And after the final survey would have been made, then a Milo title was issued. You imagine giving out a square mile which had people on it. These people, by a stroke of a pen, became landless. even if this person was a Mutaka who had utilized this land before, even if this person was a Chibanja holder who was giving his Busulu and Envujo to the Mtongole or to the Mutaka, these people lost their interest. Their security of tenure was completely eroded once the Mailo land was registered. To say whether there was a historical injustice depends on which side of the coin you are on. If you are on the side of the then government, was there a historical injustice? Sir Harry Johnson wanted to penetrate and make sure that he entrenches the British rule in Uganda. For him, he achieved what he did using the Bakungu and the Batongole, that indirect rule. Yes, he succeeded. And that agreement, whether we want it or not, is the basis of what we are in Uganda today. It affected all of us, even people who are not in Uganda. It affected all of us. It impacted on us. So from that side, yes, there was credit. There was credit that he achieved it. On the side of the Bakungu and the Batongole, they acquired Milo land. And for the first time in the country, we had land registration, which was an alien thing to us. But over time, people appreciated land registration. I'm sure all of us here, the panelists, no one would want to own land which is not registered. This is a concept which was brought then. So yes, they achieved as far as ensuring that land eventually ended on the register. But look at yourself if you were a Chibanja owner. The Chibanja owner who, with the stroke of a pen, lost out, was not consulted. There was no research, prior research done. For that one, there was an injustice. An injustice done. I was talking to one of my colleagues the other day, and he told me it was not only injustice, it was fraud. Because they took away land from these people without them knowing. And mind you, after allocation and registration, these Vibanja owners still kept on moving from one area to another, following their Mutongole or their Mukungu to settle on their Mailo land. So depending on which side of the coin you are on, yes, there was injustice, but there was also some good aspects that came out of the allocation and the eventual registration of Milo land. I think that's what I can say in 10 minutes. If I was given an hour, I think I would say more, but thank you for listening to me.
Thank you so much, Ms. Sarah Kulata. You talked about Usuru and the Envujo. Is that something you can speak to in 2 minutes, what it means for purposes of all those out there who still need to understand what this is?
Thank you very much. I hadn't dwelt a lot in that because I thought the 10 minutes was not enough. But a Mailo or a Mutaka or a Mtongole would I call it a tax, impose a tax? A percentage of what you had produced on the land would be paid to the Mailo owner, and also the Mailo owner would also pay something to the Kabaka, so that is the Busulu and the Envujo.
Thank you so much. To my panelists, any comment, any questions?
Thank you very much, Madam Kurata, for that history. I think it's very enriching history. I would like to support you about the injustice that took place. Maybe what I would like to add is that this kind of allocation of land was possible because throughout Africa, the concept of land ownership was very, very minimal. Many people would access land for use, not for ownership. And in Africa, we are used to the customary tenure. where you collectively use land without necessarily owning it. I'm sure if Sir Harry Johnston came today to allocate land like that, he would face serious problems. So the problems that happened in Uganda happened everywhere in Africa. In Kenya, in Zimbabwe, in Malawi, large chunks of land were channeled out and parceled out for other people, and yet they were indigenous people who actually were supposed to be the owners of that land. In Uganda, maybe what is unique is that they used it as a tool for administration. So the beneficiaries were not whites, like in many other countries. The beneficiaries were fellow blacks whom the colonialists wanted to use for indirect rule. Thank you so much.
I just wanted to add a couple of things. David Mpanga is my name, by way of context, and the previous speaker has added to that context. It's very important to understand that the 1900 agreement happened in a context. It wasn't an event that kind of just erupted. So Harry Johnson didn't come on a holiday trip and suddenly decide to start parceling out this part of the world. It was part of an imperial conquest that took in the whole of Africa. It's very, very important that we understand, and I'd like to underline that. An imperial conquest that happened whether we liked it as Africans or not. And in some parts, that conquest was directly forceful. In other parts, it was indirectly forceful. In some parts, it was done with deception. And in other parts, it was just done, with the naked force of the Maxim gun. So the 1900 agreement in particular was essentially an agreement of conquest. It was like a treaty of surrender. It came on the back of an attempt by the Arab faction, the French faction, which was Catholic-led or Catholic-nominated, and the Protestant faction, the British faction, which was Protestant or Anglican-nominated. There'd been wars in Uganda. It's important also to underline and underscore that in that contestation of imperial conquest, the legitimate king of Uganda was deposed. The legitimate king was Mwanga II. Mwanga was deposed by his men, by an Anglican faction, which led the deposition of the Kawaka then, and Mwanga was exiled. We also know about that history where Mwanga got together with Kabalega to try and resist. It wasn't successful. A king, Chwa, was imposed in the lifetime of his father, whilst his father was in exile, and his father unfortunately died in exile. The 1900 agreement was signed when the king, the Kawaka, was 2 years or 3 years old, Chwa. And the people who had deposed his father were the people who signed this agreement for on behalf of the Kawaka of Uganda. So the people, if we're talking about injustices, the people of Buganda who were in the Wesengeze, the Chiwanja holders, lost. The Kawaka of Buganda also lost. The Kawaka of Buganda, the Savataka, was a significant loser in this arrangement. But official Milo was designated for the kingdom, but it comes out of a situation where the Kawaka ship, if there was ownership, held all the land on behalf of all the Baganda. And the Kawaka ship was left with only a portion of the land under that arrangement, which was negotiated when the Kawaka, the occupant of that seat, and I'm not going to go into the history of legitimacy or otherwise, but the older Kawaka, the existing Kawaka Mwanga, had been exiled. The sitting king, his son, was only 2 years old and was in the control of a faction. Lastly, in trying to understand, again, the context, Ms. Kulata very rightly pointed out that the 1900 agreement brought about the settlement which is now called Uganda. It's very difficult for all of us to imagine, but it must be harder for the younger audience to understand that Uganda did not exist as an entity. All right? We really need to understand that. And the unraveling of this and the constant pulling at that string unfortunately, often we forget that the fabric of what is Uganda is essentially woven around this 1900 agreement. It was the pragmatic settlement, all right, between the African and the European, which if we completely undo it, we have to go back to before the existence of Uganda. And we need to understand it in that context. So very lastly, if we understand that historical injustice cut in different directions was imposed by larger forces than simply the people that were on the ground, we need then, in my view, understand what was done with the situation, the benefits that came out of that situation that was already bad. How did you make do with what you had? And one or two simple things that can illustrate that is, one, the 1900 agreement effectively prevented European settlement in this part of the world. And that meant that what happened in Malawi, what happened in Zimbabwe, what happened even in neighboring Kenya did not happen here. And the political consequences that went with that, the colonialism where there was strong, big European settlement, was far more brutal than the colonialism which was handled on an indirect basis. The settlement of the post-colonial arrangement was also largely more just than that which has happened, as we see in South Africa, what happened in Zimbabwe, what happened in Kenya. And the things that drive post-election violence in Kenya constantly are about the failure to resolve the land issue in Kenya, which came about because of large European settlement. So I think it's also important that we understand that in that bad situation, something not so bad was salvaged, and it prevented a worse situation here. Very lastly, and I've said lastly 3 times, but this is the absolute last. The concept, as Ms. Kulata has pointed out, of registered title holding, once that started, you'll find that although there was an initial arrangement that was not just to all, something of value can and has been obtained from that. I don't think we can, any one of us here, understate the value of registered ownership in terms of boosting security of tenure. And if we're pragmatic and proactive about it, I think that will be my subject. There are ways in which we can try and make do with what we have and provide for security of tenure and productivity without unnecessarily having to go all the way back to the beginning, because unfortunately we are where we are. Thank you.
Yes, Dr. Nakai.
Thank you very much. I appreciate the presentation of Madame Kulata, especially in as far as elucidating on traditional tenure in Buganda. I don't really think that there was an agenda. It's my opinion. There was an agenda to entrench an injustice. I don't think Johnston came around to say that let's go and do something unjust in Uganda. The fact is that there was a broad agenda to make Buganda self-sustaining. And there's a great deal of literature to the effect that one of the things behind the 1900 agreement was the desire to entrench traditional tenure. So I think traditional tenure was the starting point. As she ably mentioned, a number of people that got allotments under the 1900 agreement were not strangers to control over land. So then that takes me back to another deeper question about the fairness or the extent of if you were to measure justice, traditional tenure had, because it formed the springboard of allocations in 1900. Now, the problem with using traditional tenure as a springboard for 1900 was that beginning with traditional tenure meant entrenching the pre-existing cleavages of power, which meant the powerful that had access to control over land had their power entrenched, and those that didn't have had their powerlessness confirmed. So I think this broader context, as the previous speakers have mentioned, is very important, and I would believe that injustice was an unintended consequence of the way things were done and the modalities that were applied in the processes of distributions.
Excellent submissions right there. One submission is around governance, an easy way to govern. Another is around production. Another is around, but also the way we were structured as Uganda, right from the very start, forming the base upon which the allocations will be done. It's about the alternative truths and facts, and we're glad that we're having all this coming through to us. And so thank you so much, Dr. Rose Nakai. I want to stick with OHT Mpanga, because I think now we're delving into the whole bit around now the evolution of Milo land system up to where we are today. So we're seeing the allocations in 1900, we're seeing the issues around Mvujo and Vusulu, we're seeing all the decade-long reforms that happened on Milo, but now we're here, now. And we have landowners and we have tenants. But one of the things that is such a problem now is the relation between landlords and tenants. And with this relation, we can always say it's piggybacked on where we're coming from, but also on the dynamics around landholding now, where many people are coming in. It's not only the original allottees, but now there are very many other people that have come onto the land. So, OHT Mpanga, how are we dealing with this whole thing of the relation between landlords and tenants, and especially with regard to productivity? How do we deal with the productivity that is coming out of that relationship? Let's first talk about the relationship itself, where it is the flaws, but also what's working, but also how it can enhance productivity, because land is for productivity.
Thank you very much. I think you've asked two questions, the is and the ought. That's how jurisprudence students would put it. What is it? What's the relationship at the moment? And what it ought to be or what it can be? And I'll structure my answer in those terms. What it is at the moment, of course, is that Milo land is one of 4 constitutionally recognized land tenure systems. The others being leasehold, customary land, and freehold land. And simply understood, and I think my colleague Dr. Nakai will help us unpack that. Milo land is a form of freehold with incidences of Uganda custom. Is the best way that you'd explain it to a person who's a complete stranger to our situation. Freehold land is land held in perpetuity. It's a land tenure that we imported from the United Kingdom. Of course, the 1900 agreement having been perpetrated by the United Kingdom agents in this country. The is that it's registrable. So the holder of Milo, whether it still be a square mile, whether it be subdivided all the way down to a quarter of an acre or less, is now entitled to a certificate of title with their name on it. And the provisions of the Registration of Titles Act mean that that person's title cannot be defeated except in some very unique circumstances, which are largely to do with fraud and not being a bona fide, good faith purchaser of that land for value. Now, it still doesn't mean that my certificate of title with my name on it as a Milo owner ignores the person who was not consulted, as Ms. Kulata told us in the 1900 arrangement. That person is called an occupant in our law, and a customary tenant. And the customary tenant is generally the person who owned the chiwanja, as understood in Chiganda culture. An occupant with a homestead, with gaining their sustenance from the land, largely by small holding agriculture. But it is also now, by virtue of migration, by virtue of movements, includes occupants. And those occupants are defined in the Constitution as people who, prior to 1995, had lived on this land undisturbed by the registered proprietor for 12 years or more. Is it 15 years or more? If you don't have a legitimate system of dispute resolution, if you have people taking matters to court, and whilst matters are in court, they've taken them to the State House office, or they've taken them now to, you've got a court order, but it's subject to a police clearance, you start getting dispute resolution deficiencies. Aside from the lack of staffing in the judiciary to handle these matters, the failure of the district land tribunals. I've only got 10 minutes, but I could put it all down in shorthand. Dispute resolution deficiency is. Then lastly, we get the underlying, through all of these deficiencies, corruption. If I can buy a title, if I can buy a decision, if I can buy enforcement, if I can buy the stopping of enforcement, all these things become a recipe for poor relationships between landowners and tenants. Unless and until we address those things effectively, unfortunately, the relationship becomes poorer. Unfortunately, it becomes very difficult to make this land usefully productive. Very lastly, it doesn't help that many times when we come to address these things, we come at them with political and ideological goggles. There are people who say they've come to resolve the injustice. They come to resolve the injustice, but then what happens on the ground is slightly different. We see them allocating themselves and their cronies large chunks of land, and we see them very eager to address these so-called injustices against other people. We think that is something that essentially makes land reform discussions in this country very difficult. If you have, again, legitimacy, informed, even-handed, and non-politicized assessment of the issues and finding ways of addressing them, to my mind, you would be able to address them. It might be news to many people here and to our viewers and listeners, but in 1962, between 1962 and 1964, the Uganda government, as it then was, set up a Land Tenure Reform Committee. And the Land Tenure Reform Committee recommended a number of things, including the stopping of new Milo grants and the conversion of Milo into leasehold upon sale. It was going to be a gradual thing that would eventually see the ending of grants in perpetuity, state ownership, essentially, and ownership linked to user. It didn't happen. It didn't happen because the report came out in 1964 or 65, at a time when the politics had taken over, and it became a contestation between Uganda Kingdom, central government, 66 happened, etc., etc. Ever since then, each time people have come to deal with land sector, they've said we're reforming. Why doesn't it happen? Or why don't the reforms yield the thing that we're looking for? Unfortunately, that lack of legitimacy, that lack of even-handedness, the political goggles which inform the reform prevent us from achieving what we need to achieve. So, in summary, there can be and there ought to be coexistence and useful productivity between landowners and tenants. There are many ways in which the security of tenure of the existing tenants, of existing occupants, can be addressed. Those ways are suggested in different fora. My neighbor here recently was on a commission of inquiry, and I'd like to hear, we'd very much like to hear what the report, what they said, but we are still waiting for the report. But as I say again, it's important that whatever reform, if it's to be sustainable, that reform must be informed by the necessary information on the ground. It must be led by an even-handed effort to genuinely resolve, and it must take into account the interests of everybody rather than simply come along and say, I will benefit from that arrangement. I'm going to turn all my Milo land into freehold, And by calling it freehold, suddenly, apparently, there's no problem with it. And then I'm going to reform the land of everybody else that's allegedly left as Milo. We must take into account that the so-called injustice situation now includes people who bought land, and they bought it because it was a registrable, recognized, lawful asset class. And they bought it subject to encumbrances, of course. But if we simply say we're going to come along and remove you and give to other people, that's an injustice now perpetrated to these people who bought with their good money. And if we're giving to people who are on the land, maybe those people are not the losers. When 1900 happened, my ancestors were in Namulonge. In fact, we don't know where my great-great-grandfather's grave is, because it's in the area that is now Namulonge Research Station. And we don't know whether it was removed or not. But we went somewhere else. And that somewhere else, we've also now become Milo owners because we bought. So if there's a redressing, can I, the person who lost out in Namulonge, go as the descendants of those people and say, I'd like a piece of Namulonge? If I can, just think about this chaos. Sena grounds, just think about that whole conference center area, parliament. All these places had people who lived there, who cultivated there. All right? If all of them turn up, how do we proactively deal with that? So we also need to ensure that we deal with things proactively and constructively. That would be my contribution for now.
Well, thank you so much, Oweekitiibwa Daudi Mpanga. Oweekitiibwa Daudi Mpanga is the Minister for Special Duties in the Kingdom of Uganda. Just one question to you. I know that much of what you've said must have tickled Dr. Rose, but I believe that Dr. Rose Nakai will be talking about this in her presentation. I just have one more question for you, and if you can address it in a minute. You've talked so much around the administration, the bit of the corruption, the impunity. I love the fact where you said someone can buy the title, buy enforcement, and buy the stopping of the enforcement. So it's amazing. But then we also look at the other side where we're seeing landowners and tenants actually fighting, where someone comes to open boundaries and they're at the person's throats. The surveyors have been on the receiving end of this because they've been hacked when they go to do the survey work. What has gotten us here, but also how do we address this challenge, especially also as someone coming from the kingdom and with valuable experience in dealing with this?
Very quickly, and it was not my intention to tickle Dr. Nakai. If she was tickled, I apologize. Very, very quickly, the situation that pertains between landowners and tenants can be and should be more cordial. It has been in the past. It has been soured in a number of ways by people who wish to ignore the encumbrance that land registration comes with and the responsibility. And also, as I said earlier, people who are more corrupt, who have more force, etc. The pushback also includes, people protecting themselves. I'm not going to say I encourage people to take the law into their hands, but when you're put in a position of feeling powerless, when you're put in a position of being deprived of your basic rights to shelter, to life, essentially, some more drastic and reckless measures may not be surprising. Of course, the Kingdom of Buganda doesn't encourage this. The Kabaka of Buganda holds as an office about 6% of the land in Buganda. And the Kabaka of Buganda, in administration of land, as a Milo landowner, to my mind is exemplary, because you don't hear largely of the Kabaka of Buganda coming into violent confrontation with tenants on the Kabaka's land. It's a system that very usefully could be and should be adopted across all of us landowners and tenants, an arrangement that tries to make do with the situation that we have, either by leasehold tenure or in the absence of leasehold tenure, because you can't force a person to take a lease, at the very least registration as a Chivanja holder, so you are known and your area is surveyed and clearly demarcated, and you have better security of tenure and an understanding of who the registered landowner is. The situation that leads to violence, that leads to assault of even surveyors who are really agents of a landowner doing nothing but opening of boundaries is wrong, should not be encouraged, and should be condemned, actually, more than not just encouraged, not encouraged. It should be condemned. But it comes about, as I said, on that backdrop of, unfortunately, corruption, impunity, deficiency in dispute management, overlapping and deficient administration, overlapping and corrupt, deficient dispute resolution, which must be addressed.
Thank you so much, OHT Wampanga, Daudi Mpanga. We will get back to you and to all the other panelists to speak more to the bit of the relations on Milo land. I would love to read out some of the comments that are coming through the chat window. If we could project. Okay. Thanks for all the comments. I could see that we have over 250 people following us online, which is great. So thanks for following this discussion. And I could also see that there were a couple of comments coming through the chat. So we'll be able to read them out loud when we're able to project what it is that we have. So thank you. We want now to get to the other technical aspects of Milo versus the other tenure systems. Dr. Nathan Batunji, who's a land tenure researcher and is also a surveyor, we want to get to that discussion of Milo land versus the other tenure types. We have heard OHT Wampanga talk about Milo land, and he defined it as a form of freehold with incidences of Chiganda culture. That is how he defined it. And you know, it was an interesting definition, and it's something that we need to get back on, because one of also the very interesting discussions we had when the first draft of the report from the Commission of Inquiry led by Honorable Justice Catherine Bamgimerere came out. They also talked about getting rid of Milo and then having freehold, and this discussion still came up, the Milo and freehold. So Dr. Nathan Batunji, what is the feasibility of adopting a uniform land tenure system in Uganda? How feasible is it to have a uniform land tenure system in Uganda? Because then we are seeing all these issues surrounding the different tenure systems and how the clashes are coming in. So what is that feasibility? What do you think?
Thank you very much. Okay. Thank you very much, moderator. The question you have asked also leads us to another question which I thought should be answered first. And that is knowing what land tenure actually means. I want to start by defining a land tenure by saying that all over the world, the traditional tenure systems were more or less the same, and they have an element of landlord-tenant system. So people lived on the land, and they also had other people who were working on the same land, and they didn't complain. They lived very comfortably. Now, we have a second system, which is the formal, what we call formal tenure system, which follows the traditional ones. What does the formal mean? Formal means recording the ownership. And the history of land tenure started in Western Europe in the year 1000, and that was during the feudal era. So land by that time was a form of wealth, but they had to record it in order to tax people. Now, you couldn't tax people if you don't have a team of people to record. And the people recording were the cadastral people, the surveyors mainly. Then they also had registrars, the lawyers, to record the link within the ownership, who owns what, and keep it under an understanding system. So land was a form of wealth, land was for sustenance, but under the feudal era, which lasted from 1,000 to 1,750, or that period, which is known as the feudal era, land was only held and it was like a property. But in the meantime, as the Industrial Revolution era came on, they realized that they needed land as a form of production. So land had to bring in capital. It was a form of capital. And they realized that these landlord-tenant tenure systems could not sustain the Industrial Revolution. Land had to be owned individually by a person. Each one would get now a title. So they moved from just recording it for taxing and giving government. They now moved to people using the land to get capital. And this now took us to the Industrial Revolution, which started from 1,750 to 1,950. Those 200 years was known as the Industrial Revolution. And this is what was being done within Europe. Now, it so happens that when the Bazungu, the colonialists, came to Uganda, it was towards the end of the Industrial Revolution. So for them, they knew the tenure system very well. They knew what traditional tenure looked like. And they knew what the tenure system under the feudal system, where it was now formal, it was recorded, everybody's land was recorded, but just recording mainly. And that they had to use surveyors, they had to use lawyers for registration. So the systems now of registration and cadastre starts within the feudal era. So when they came, they were having these tools. Now they came to Uganda. Johnson, you have heard about, came to Uganda with special instructions from the Queen to introduce freehold. Now, freehold and leasehold they came onto the scene in the Industrial Revolution era. They are the ones which phased out the landlord tenure systems. So what I can say here is that the landlord tenure systems are actually the traditional systems. But here, they were the traditional ones, but recorded. That should be understood there. Recorded, just everybody who owns it is written down in the books of government. He pays tax for it, and that kind of thing. So when the Johnson came and came to Uganda, it was Industrial Revolution era, and the tenure systems that were now had evolved were freehold and leasehold. So he came with instructions to do that. And the place he started with was Buganda. Uganda, of course, was on paper, but they had to start from Buganda and win every district that was, until Uganda was completely won in 1936. These people came in 1980s, but Uganda to be under the control of the British was in 1936. So when they came, they wanted to impose freehold and leasehold. Now, this was not possible because ours was traditional ownership. Uganda had a traditional ownership. They had their scheme of owning the land. So they put up resistance. And when they put up resistance, Johnson tricked them into dividing Buganda into two parts. Buganda was divided in two parts. One part, he said, you people, you can now live on one part, like half of it, which eventually came to be called Milo. Then the other part, he said, this now is owned by the Queen, and the Queen took it over. Now, the part that was owned by the Queen, they could now issue freehold and leasehold on that part of the land, half of Uganda. And on the other half, now that became Milo. At the end of it all, it so happened that by the time the colonial administration left, they had introduced the type of Milo land only in half of Buganda In Ankole, they introduced it to about 50 square miles, or maybe about 70 square miles in Ankole. Then in Toro, they introduced this Mailo land to about 350 square miles. But then they realized that the problem with Milo was it was still landlord tenure systems with overlapping rights. Customary tenure has overlapping rights, and leasehold and freehold have individual land rights. So the difference in here is that if you have individual land rights, you are good to go for production at a capital and industrial level. But if you have overlapping rights, production becomes encumbered because nobody is actually owning which, and that becomes a problem. So now, by the time the colonialists left, they had introduced Mailo land in 1900. They had introduced what is called native freehold also in 1901. This is native freehold is the one in Ankole and the Toro. But native freehold and Mailo are actually the same. There is nothing different. Then they also introduced leasehold in 1902, and they also introduced freehold also in 1902. Then, before they left, they introduced adjudicated freehold in 1958. Now, what is the difference? Milo and native freehold, which I said are the same, they have what we call overlapping land rights. Therefore, not conducive to development as the new aspect was concerned. But leasehold, freehold, and adjudicated freeholds are full individual land rights, which are like modern tenure system. So these are the 5 tenure systems that they introduced. Now, in 62, when we got independence, the colonialists left. So when they left, we had our own government. So what did our own governments do with this land? In 1975, Idi Amin wanted to do away with overlapping land rights. And he actually decreed against them. He abolished Milo, he abolished all the freeholds, he only left leasehold as a uniform land tenure. But the problem that he had is that he did it using the law just abruptly like that. But in land tenure systems, it is better to move from one system to another gradually. If you put in force, you create a problem. So I mean, put in a bit of force of the law, and it never worked. So the next stage that this matter was handled was in 1995, when the NRM government came in power and then decided to handle the land question through a constitutional commission headed by Odoki. Now, at this level, the Constituent Assembly was faced with the problem of what do we do? If leasehold has failed to stand, what do we do? Now, it so happened that the Constituent Assembly had papers. There was a research from Bank of Uganda which had recommended that freehold is the best tenure system for Uganda to support agriculture. So that paper was submitted to the Constituent Assembly. Then the Constitutional Commission write-up, which was considered by the Constituent Assembly, also had worked on land. They had answered the land question. And they came in saying that people are comfortable with all their land tenure systems. In fact, they said Milo land must be brought back, as opposed to a means workup. Freehold must come back. That was the views of the people. Then, when that became a dominant supported position, and yet there was also another paper saying freehold must be a uniform tenure for Uganda. In other words, let us have a uniform tenure right from today. It became a big tussle. And for those who are following the argument by then, it was a very big tussle. But there was a clever way out of that. At the end of it all, it was agreed that actually freehold is the uniform tenure for Uganda in the constitution. And the way they did it was to say that we shall only have it gradually. It will not be today. So what we do, let us reinstate all the other tenure systems that we were. But they were very careful now. They instituted the customary tenure for the first time, which had not been recognized. They reinstated leasehold, they reinstated freehold, they reinstated Milo, 4 of them. And one good thing they did at that time was also to say that the land must belong to the people. I am looking, I have this paper where I had specified that the land is either owned by the people as the supreme authority, or it is owned by the state or the king as the supreme authority. I have not gone into those, but it's because of short time. Now, at that time, they moved from the state, because Amin was giving away this land because he was owning it as the state. Now, we were angered by the Amin's reaction, doing things like that, and then it was now put back to the people. Then what happened is that the Constituent Assembly put an instruction. It instructed Parliament to look at Milo land and give registrable interests to the tenants, lawful and bona fide, and also give registrable interests to the landlords. Now, when Parliament came to handle that assignment after the Constitution was done, they messed it up. The National Land Policy messed it up. The Land Act messed it up, in the sense that they started a new argument altogether and did not act on the instruction. The instruction is in Article 237, subsection 9, Section 9, subsection B. If anybody who has got the Constitution can look there and see. That is the instruction that they have to do as a Constituent Assembly, which is in our Constitution, which says all the land must be registered. Now, when they went back to put the enabling laws as Parliament, they messed up the Land Act, they messed up the Uganda National Land Policy, such that as of now, there are sections like Section 36 of the Land Act, which is window dressing. They wanted to use it to answer the question they had been given by a Constituent Assembly, but they didn't do it very well. They still meandered around. So my conclusion here is that if we want to have a uniform land tenure system, all we need to do is to know that we have a constitution which is perfect, giving us the freehold as uniform tenure, but the only hurdle is in the Uganda National Land Policy and the Land Act. And I have, in this paper, I have specified which section, like Section 36, which I think should be amended. And if it is amended according to the recommendations, can I read the recommendations only? Just what I recommended. I recommended that this 36, because I insisted on it, that in 36 sections we should include a sharing ratio formula agreed upon by the majority of landlords and tenants. And in the discussion I had looked at, for us survey, I've seen that people have agreed on a 60-40 dividing formula, where the landlord takes 60 and the tenant takes 40. But the landlord also takes the responsibility of surveying and producing 2 titles. That the majority of the people I've worked with have agreed on that. So another recommendation I'm putting is that Section 36, subsection 2, Section 36, subsection 2, subsection B, it says that they should subdivide the land, and still, after agreeing to share, and they have shared, and everybody is now owning land individually, they should still register these titles in Milo. I am saying that they should now register them in freehold to be in line with the Constitution. Another thing that I'm raising as a recommendation is that very many Ugandans now who acquired Mailo land by purchase, we do not have the problem of overlapping rights, which are a definition of Mailo. We don't have that problem. So can we be allowed to convert these Mailos to freehold? And once that is done, it should only be allowed to done gradually. We don't want a fight. We want government to put an enabling law that this thing is left to be handled by market forces. I thank you very much.
Wow, thank you so much, Dr. Nathan Batunji. You bring out so much information. You do so much on the legal provisions. You also speak to your core function of registering land. One of the things that Dr. Batunji emphasizes is that the individual land rights as conferred in freehold and leasehold are rather, the contestation now is as freehold and leasehold give the individual land rights, there's an issue with regards to overlapping land rights. And one of his recommendations is that for those who have Milo land that is not encumbered, where they're not having issues with tenants, they can be given an opportunity to transfer, to convert it to freehold. Interesting recommendation. But he also talks about freehold as a uniform tenure for all. Many questions come through my mind with this submission, but I want to pick on the experience of Ms. Sarah Kulata, who was with the ministry. And Dr. Batunji kept saying, the Land Act messed it. The National Land Policy messed it. And he was talking, I think, with regard to the bit of the registration of the land. What's your thought on him saying that what it is that should have put right is what went ahead to mess it? Give us your thoughts, Ms. Sarah Kulata.
Thank you very much for that. For me, I want to start, and for that presentation, very passionate, giving us the history of this land recordation from the industrial era, from the feudal to industrial. On my part, I want to define freehold as we define it from school. This is ownership of land in perpetuity. Now, if it's ownership of land in perpetuity, now let's go back to the tenure systems we have. What is Milo? Ownership of land in perpetuity. What is customary? Ownership of land in perpetuity. So why don't we call it one name? Since all of them are ownership of land in perpetuity. My brother here gave us a definition of Mailo land, that it's freehold with incidents of Chiganda culture. When you read history, they say Johnson's intention was to give out freehold. And that was the intention. But the Chiganda culture then, the Batongole and the Bataka, they didn't control land. They controlled people. So there was a misconception of what this allocation was. Actually, the true meaning of this allocation came many years after. I think it was around 20 years after, when they realized that actually they are not controlling the people, but the land. So, for all intents and purposes, Milo is freehold. Milo is freehold. We would have to take that debate further and see how do you then stop those overlapping rights. The only issue with Milo here in Uganda is the overlapping rights. They are tenants when somebody has the legal document. It's not only here in Uganda. The same tenure is also found in Ireland, where they gave out land in a similar way. And they were tenants. But government did a deliberate effort. You know, once you have a title, it is state guaranteed. They cannot just take it away. Because if they do, it means that even 100 years from now, another person can also erode those rights, just like that. So since it's state guaranteed, you cannot just terminate that title, in my view. And these overlapping tenures were caused by the state. So the state must have a proactive way of ensuring that the overlapping tenures are harmonized. Before 1975, these landlords and tenants were living harmoniously. Every landlord knew his or her tenants, and the tenants knew the landlords. Every tenant knew his or her boundary. And the tenant's boundary, the tenant's ownership used to be known by a certain acreage. It was unheard of for a tenant to claim a chibanja of a square mile. No. A chibanja actually used to be a maximum of 9 acres. If I could be corrected. Maximum of 9. If you had a capacity to use more than 9 acres of your chibanja for production, then you were encouraged to become a landlord in your own right. The landlord would be encouraged to subdivide, and you also become a landlord of those 9, 10, 12 acres. But now you find a landlord with a square mile, and he cannot touch an inch of that soil. The soil is being claimed by one person as a tenant. That was not the law as it was then, because the tenant's ownership was known. So that's why I'm saying, since all tenures, Milo, freehold, and customary, are all ownership in perpetuity, I don't see the reason why we don't have one uniform tenure. Thank you very much.
Thank you so much. Please, let's pass it on to Dr. Rose Nakai. Dr. Rose is coming on next, so let me read the comments. I'm going to afford you more time than it is you have, so that you respond to this, but also make your own presentation. But first, let me go through the comments that are coming in from online. Thank you so much for the comments that have come in online. I'll take some time to read them, and my panelists will each look at what it is they can respond to. I can also take the liberty to let you know, to allot. Land was allotted, then now I'm allotting questions. The liberty to do that. So this is a comment from Mr. Mutahi Enoch. He says, Sir Harry Johnston had 2 paramount instructions from the Queen: restore civil order in the protectorate and make the protectorate self-sustaining. Number 2 formed the basis of land allotment. There was no intention of entrenching an injustice. Joe has a question. I want to know the basic difference between Milo and freehold and the difference in the rights of such landowners. Is it better to buy Milo or freehold in the Uganda today? That is from Joe. Lugamba Gerald asks, why is public land always not considered a tenure, yet many people are occupying such land? And how different is official Milo in some areas? We have Gonza Alosias. Is it possible to relate a strong or efficient LC system to a harmonious relationship between the landlord and tenants? Is it possible to relate a strong and efficient LC system to a harmonious relationship between landlords and tenants? Can we say that because of the LC system, there is a harmonious relationship? What is the main target? What is the main target in removing Mailo land? What? Who? Well, the question is, what is the main target? Frida says, my concern is that it's necessary for us as a country to have more reforms. Is it necessary for us as a country to have more reforms on Mailo tenure? Should we not first assess to what extent the previous reforms have been implemented? Is there a really need for reform on Milo tenure? Dr. Nakai, I want to pose that to you. What happened to Milo land sold to whites to do commercial agriculture after Idi Amin sent away the whites? Was this land taken over by the government? We're going back to our history. And Vincent says, I don't think we have a uniform tenure system in Uganda with this regime. Look at the decree of 1975. Let me also get up there. I'll pick like 5 and I will go on. Please scroll down. No, scroll up. Okay. Please, yeah. Please go up. What am I saying? I'm saying you scroll up. Okay, thank you. Haj Katanzi says, freehold tenure, one holds freely in perpetuity. Milo is a type of freehold, but with Uganda customs. I think he was reiterating what WHT was saying. From Mugambi, what happened to Milo land sold to whites to do commercial agriculture? Please go up. From George Odaya, please shed some light on the land tenure system in Busoga. When does someone qualify to be called a tenant? When does someone qualify to be called a tenant? Frida says, I would like to get the panel's opinion on the land fund. Why is it not working? I really want to hear something about the land fund. I'll pick just two more. Dr. Nassan, answer the question from the moderator. How feasible is a uniform land tenure system? That's from Mr. Edin Sambagaiya. And also Dr. Batunji confirms that Sahara region so divided Buganda into two parts. That is, Madam Sarah Kulata, thanks for presenting. Okay, I'll leave it at that for now. I'll pick on other questions. So now let's have an opportunity to go the legal way. Everything legal has been said by all the panelists that have presented. But now we want to have the very legal opinion on the very understanding of Milo from Dr. Rose Nakai, who's a senior lecturer in the School of Law. So, Doctor, how do we fix the legal and policy dimensions to the Milo impasse while drawing the lessons from the past attempts? We've had very many attempts. The last attempt was the Land Amendment Act 2010, which talked about issues of Busulu, issues of tenant-landlord relations. We've had all these attempts, but the impasse still exists. How can it be fixed? But also, please take your time, not so much time, but take your time to also respond to some of the issues that came up. You kept nodding or shaking your head. It was clear some were going the other way.
Okay, thank you very much, moderator. Allow me to first make a few comments about the presentation that was made by Dr. Batunji. Dr. Batunji, I've read your book, and I've read some literature that you've written, for example, with somebody called Ruther. And it seems very clear that you advocate for a uniform tenure system. But one of the questions that usually comes to my mind is, why must Uganda have a uniform tenure system? And the reason why this question is pertinent is that my understanding of tenure is how to deal with relationships of people about land. And relationships are not usually static, but they keep on evolving depending on the context within which they are placed. And of course, I go deeper to wonder, do we really still have that traditional distinction between Milo and freehold, as one being for perpetuity, in perpetuity, and another being whatever it has been described to be? You know, you've ably given us the history of Europe. And of course, I believe that the social circumstances there, the political circumstances and the culture, cosmology, and all those issues of those countries justified the existence of the tenures they had. And when I come to Uganda, I really believe that the multi-system of tenure we have today is not an accident, but a product of a number of Ugandan features. If you look at the historicized narratives that have been ably given to us by, for example, Madame Kulata and OHT Wampanga, you find that Uganda is unique. So we can't really just start saying we need a uniform tenure system without paying attention to the peculiarities of Uganda that brought us to where we are. And when I come to Uganda and I look at some of the processes that led into this agenda of uniform, I find some unanswered questions. I can give an example of the study he referred to. the 1989 study on land, agriculture development and land. That study done by the McCarey Institute of Social Research and the Land Tenure Center of the University of Wisconsin. That study intended to see how land tenure can facilitate agriculture development. Field work was done in Masaka and Luwero. They spoke to a few farmers. They came up with this humongous recommendation of freehold for Uganda. I mean, what does somebody in Kapelabyong or somebody in Amorata or somebody in Kapiripirit or around here in Buganda, why should that person be a subject of this imposition as a result of a study that was done for a specific purpose with a small, group of people that were interviewed? So the point I'm trying to make is that if we want freehold for Uganda, we need to do the right things. We need to go to Uganda and try to establish whether that is the best for them. And when I look at the Land Act, the definition of tenure in the Land Act that we have today, I find that freehold is no longer as attractive as it was traditionally, because it is defined as a tenure which grants rights in perpetuity or less than perpetuity with or without conditions. Really, do you want me to give up my Milo title that has no occupants for a title that might be less than perpetuity with conditions? I think we really need to understand, why things are the way they are, and you try to find appropriate solutions after clearly understanding the appropriate problems. And then, is freehold attractive? Well, indeed, as it mentions in the Land Act, the agenda to make Uganda freehold is seen in the provisions for direct conversion of customary tenure into freehold. We all know that customary tenure is the widest. So if a big percentage of customary tenure was converted, that agenda can be achieved. But if I have my customary land and I'm seeing a holder of a freehold title complaining that 2 other freehold titles are sitting on their title, aren't I happy to deal with the chief rather than start fighting with state agents and bureaucrats about my title? So I really think the debate needs to be taken further to actually come to a conclusion, which is my view, that the most important thing is ensuring or guaranteeing security. Security that can make land attractive on the market. If my tenure is secure, I don't care if it is customary, if it is freehold, if it is Milo, because the community or the market will trust my land if I want to sell it, or I would be in position to use it for whatever I want to do. So names are important, but the intrinsic value lies in the security. It doesn't matter if I have a freehold that is not secure and someone has a Milo that is secure, or vice versa. Now, if I may come to the question that the moderator put to me about how to fix the impasse. I had planned to describe the impasse, talk about, secondly, how the legal and policy framework tries to fix it, and the lessons that we learned from the past. I'm glad to be speaking after Madam Kulata and OHT Wampanga, who actually gave us the history and somehow described the impasse. And in brief, I would say that the impasse on my land is basically the existence of a title in somebody, inability to use that title fully because it has somebody with a secured occupancy. That somebody can only be evicted for non-payment of rent. So it means there's a possibility that the landowner might become desperate to get some value from their land, but they cannot. There's also a possibility that the landlord might want to sell their land. The law allows the landlord to sell the land and the purchaser to take that land subject to the rights of the tenants. And what this means is that there is a conflictual relationship that is created by that provision of the law in the Land Amendment Act 2010, because the new purchase of this land might not necessarily have any relationship with the tenant. They might want to get value out of their land immediately, and the next thing would be evictions. So the impasse is characterized by increasing conflict over land, increasing evictions, and a desperate situation where parties to these conflicts are not always guaranteed of a remedy. I was listening to the principal judge during the last judges' conference, and he mentioned that the backlog in the land division was about 5,681. So if somebody doesn't want to go and queue behind 5,000 cases, it means the relationship becomes complicated because there isn't necessarily a guaranteed way of resolving this dispute, and that therefore creates this impasse. Now, a number of land reforms have taken place in Uganda, and some of them have been alluded to by the previous speakers. The one I find most far-reaching is the Land Act, or the contents of the Land Act are the most far-reaching land reforms. So the agenda behind the Land Act broadly was to, first of all, ensure that there is security of tenure that will promote land, or that will push land on the market and allow those that can progressively utilize the land, utilize it after purchasing it on the market, securing the interests of the occupants on the land, and thirdly, efficient land use. Those were the three broad agendas. But sometimes when I look at what is happening, I get to think that maybe there is a mismatch among the broad agenda for the Act, the actual provisions on Milo land in the Act, and what is happening. I think there is a mismatch. But generally speaking, the effort to deal with the impasse embedded in the Land Act and the policy that I would like to emphasize on is the need to merge interests of the landlords and interests of the tenant. The Land Act provides a number of ways through which this can be done. Either the landlord and tenant selling to each other, becoming joint holders of this land, or the landlord allowing to give a tenant an interest. The specific section in the Act lists freehold, Milo, leasehold, and Milo as the interests that the tenant can acquire. I usually have a question about the freehold. How can somebody with a Milo grant a freehold? I don't know what the drafters had in mind. But the point is that the interests can be merged. Now, when we talk about merging of the interests, of course, money becomes an issue. The land fund is provided for in the Act to provide resources whereby the government can purchase land from the landlords and give it to the tenants, or the tenants could borrow money to purchase an interest from the landlord. But before that ultimate is achieved, there are interim approaches to secure the occupants of the tenant. The tenant can acquire a certificate of occupancy provided for in the law, but they haven't been popular because it has to be secured with the consent of the landlord. And very few landlords would want to encumber their land. Now, the key question is, why haven't these provisions delivered? I would like to mention that there has been a problem with corruption. I think we've seen a number of court cases that somehow show that the land fund has somehow been unable to handle the situation because of corruption. It is also possible that the prioritization, because when you look at the land sector strategic plan, you find that priority is given to the Chibale land question in terms of the land fund. So which means Milo holders elsewhere would not come before the Chibale land claimants. But then again, do we have the institutional capacity? There has been a problem of institutional capacity to facilitate these processes in the law. For example, the negotiations between the landlord and tenant are supposed to be facilitated, but the institutional framework wasn't clear. So the land policy comes up to say that mediation committees would be set up in order to facilitate these processes. The land policy also comes up to say that if landlords cannot receive the rent, it could be paid to the sub-county. The same land policy also comes up to say that the new purchaser of land from a landlord who holds land that has tenants will have nothing to do but to take up the obligations of the previous tenant, landlord, in as far as the tenants are concerned. Of course, there are quite a number of issues here. The policy comes after the law, and ideally, it should have come before the law to guide processes in the law. What this means is that we find ourselves in a vicious cycle of having to reform the law in order to put it in line with the policy, if that's what must be done. Now, the other key question that the moderator asked me is about what lessons do we learn from the past? The first lesson we learn is that top-down approaches of land law reforms do not necessarily produce results. And of course, we learned that from the distributions of 1900. As I mentioned earlier, they did not necessarily produce very deeper reforms that would benefit everyone because of inclusion issues in terms of developing the framework and implementing it. So we need to learn inclusion is key in terms of coming up with law reforms. Then the other lesson we learn from history is that if you don't do it right the first time, you might do it better the second time after an uprising. We know that human rights are most times a product of resistance or rebellion. We learn from the reforms of the 1928 Busulu and Mvujo law that the first time they failed to protect the tenants on land, we got the Bataka movement and we got the Busulu and Mvujo law, which somehow had progressive provisions that were protecting the occupants on land. They were secured and they were able to produce raw materials. They were protected from evictions, but at the same time, they didn't necessarily forget the landlord, because when you look at some of the sections of that law, for example, 16, you find that the landlord who had no land would apply for an order of eviction against the tenant to release some of the land they held in order to avail it for them to use. So the law tried to strike a balance, and indeed, we saw some positive results. Then the other lesson I want us to learn, or reform processes should learn from history, is that it doesn't have to be too big and impossible to implement. The 1975 Land Reform Decree that Dr. Batunji alluded to earlier is one example, with a broad agenda of promoting the progressive farmer by allowing them to access land. It required a lot of work to do to convert all Milos into freeholds, to have institutions acquire freeholds. It required a lot of administration and a lot of finances and no preparation for that. So let's dream big on national issues, but not be too big to be possible. Because at the end of the day, state bureaucrats and agents, cronies, ended up using the idea of promoting the progressive farmer to displace the poor occupant on land, because there were no safeguards put in place to promote a national outlook that would deliver for all. So as we think about all these debates, some of which have not been formal but out there in the spaces, nationalize land, promote freehold over all the other tenures, we have to bear in mind the lessons of 1975. It can be too good to be true or to be possible. And then I would also like to mention that from the reforms that have happened in history or efforts at reform, he talked about the committee that investigated tenure relations. We had the Carter Committee that did some work. We had the East African Royal Commission, whose recommendations were resisted, for example, in Teso, because they didn't really seem to be for the people, without the people. So sometimes I think it's important to think about these things in terms of taking a social domain model. How do you pick the practices that have evolved on the ground to give them the force of law? As I mentioned at the beginning, tenure isn't static. It's evolving depending on the circumstances. So rather than imposing from the top, why not pick from the ground and then come up with a product that is informed by legitimacy and therefore will be easy to accept and implement? And also, lastly, institutions. The governance question with regard to institutions of land administration needs to be addressed, because 1,000 reforms that are implemented within the same framework will not necessarily deliver. I was reading the newspapers recently, and a certain surveyor had written about the closure of the Wachiso land office. So we need to be talking about progress. We need to be talking about strong institutions, because it is these institutions and facilitation plus the will of the people that can deliver. Thank you.
Thank you so much, Dr. Rose Nakai, for ably breaking down the bit of the impasse and acknowledging the contribution of all the other panelists to breaking down the bit of the impasse. Some of the key things that I pick out of your presentation, I'll just pick out two where you say the most important thing is guaranteeing security that can make land attractive in the market. And you're talking about the intrinsic value. You're saying that intrinsic value lies in security. Regardless of the tenure type, the intrinsic value lies in security. The other thing that you say is, do you want me to give up my Milo land without any encumbrance so that I can get a freehold that may not be held in perpetuity, but also that could come with conditions? Is that something that you would want to see happen? interesting question, especially to Dr. Nathan Batunji, who had talked about freehold as a uniform tenure that should come through. And maybe the other thing is we can talk about nationalizing land and a bit of promoting freehold, but then it could have the same fate as the Land Reform Decree of 1975. Those things that are too good, but they never really come to fruition. Dr. Batunji, I feel you would love to make a comment on that, on Dr. Rose Nakai's submission on freehold.
Thank you very much, Mr. Moderator. I think Dr. Nakai has touched on very many things and has had a chance to comment on the work of previous presenters. I have two issues that I would want to clarify more concerning the land rights of freehold and land rights of Milo. I think we should all agree that freehold has rights which are held in perpetuity, not with any condition. I've not seen anybody with a freehold complaining that at one stage government will take it away from him or something. Also, Milo is in perpetuity. But what we all know about perpetuity is that even traditional tenure systems were held in perpetuity. So perpetuity is not something new. So to move from freehold to Milo, to move from Milo to freehold, I think we better look at what is the position of our constitution, the Constitution of 1995. The Constitution of 1995 actually agreed to freehold being the uniform tenure. And that is the reason why customary tenure, which was accepted within that very discussions, was allowed to convert to freehold, because they had made it as a standalone tenure system, but at the same time, they allowed it to convert. If you want registrable rights of customary tenure, convert to freehold. That one is in the Constitution. Now, when you look at freehold, the main problem of the Constitution, and it is documented, is that they found that it was not prudent. I think that's the word they use. It was not prudent to all of a sudden declare that we have given you freehold. But they said that the biggest handle was because of development. In fact, they talked about two things. Socio-economic development in Uganda is not equal in all regions. And secondly, educational literacy is also not equal. So the fear at the Constituent Assembly was that if you declare it, some region might get freehold faster than another region, and then we'll cross over to another region and also get freehold there, making people go on the streets. So they said, let us do it gradually. That's the spirit of the Constitution. So freehold is not an issue. It's not a new thing that you can debate. Freehold will become a tenure, a uniform tenure for Uganda, only when these two conditions are sorted out. Literacy has covered a lot of Uganda, and socio-economic development has also covered a lot of Uganda, everybody knows, and capital is required from land as it is. So when that situation is reached, then we shall make sure, there will be no option, but freehold will become the tenure. So that as we discuss now, let us not waste a lot of time thinking that we do not have a uniform tenure for Uganda. We do, but its time has not come. And that's the position of the Constitution. But what we need to do is to go back to the National Land Policy and to the Land Act and include in sections that will allow that gradual growth. And as I conclude, I want to remind you of what I said, that when when the landlord tenure system was changing to leasehold and freehold, it was phased out. There was nothing abrupt. And that gives us a way of how tenure system should change. There should be nothing abrupt. In other words, all these suggestions where they are saying that we should have a land fund, that is trying to do it quickly. We need not to do it so quickly. We need to allow it under the market forces to go gradually, but we need laws that allow that gradual growth. That's what I think we should do to ensure the uniform tenure.
Thank you so much, Dr. Nathan Batunji. The beauty about alternative truths is that they are based on knowledge and less on sentiments. So listening to Dr. Batunji and Dr. Rose, it's for us out there to go and research more and get a deeper understanding of these tenure types. We want to tap into the benefit of Dr. Rose being a part of the Commission of Inquiry that was headed by Honorable Lady Justice Catherine Bamgemereire. We haven't been able to look at the report. It's not been shared publicly, and that may not be on your part. But we are seeing this discussion around Milo now in the political space. Some of us are tempted to believe that maybe part of your report, because part of the discussion is that the basis of these reforms is the report and the recommendations that you provided. With the benefit of you being here, can we say that that's quite accurate? That the part of the reforms that are being proposed are a consequence of the findings and the recommendations from the Commission? You can tackle it any way you want to talk about it.
You asked me the question and then answered it at the beginning, because you've said you've not seen any public discussion of the recommendations, So I haven't seen anything that obviously shows that there is a connection between these two. I personally haven't seen.
The beauty about being a moderator is that you can ask again. So, I'm asking again. In all the discussions where the minister is talking about reforms on Milo, there's an understanding that these reforms are partly occasioned by the findings and recommendations from the report from the Commission. We've not had the chance to look at this report as the general public. And we would love to hear from you. Are there recommendations for reforms on Milo from the report that the Commission presented to the President? So we can start from there. Maybe
There are two questions here. Are there recommendations, and what are the recommendations? I'm very sure there could be recommendations, but I don't really think I can start discussing what are the recommendations. But as I mentioned earlier, I personally don't really see a very close connection between the current debates and the Commission. Because when I look at the policy, it looks like the land policy envisaged, further land reforms for the particular purpose of putting the Land Act in line with the policy, just like I mentioned that the Act preceded the policy. So I don't exactly know the content of the suggested reforms, but as I mentioned earlier, I referred to particular strategies, that is 45 and 46 in the policy, that make that projection to reform Milo land and put it in line with those suggestions. So I can't really know whether the current ones are going to be exactly about that or broader issues. I don't have the privilege of knowing the insider detail of that.
Thank you so much. I can't ask anything more than that. Thanks for the response. We can choose to understand it each on their own. Thank you. Any other comments? Okay, now now we have the opportunity to listen in to our last panelist. Our last panelist is Dr. Mhumuza. Dr. Msinguzi. Sorry, Doctor. Professor Msinguzi is going to be discussing the fit for purpose land administration and how it can help in solving landlord-tenant impasse. Fit for purpose. There's a lot of discussion around fit for purpose. And I think the discussion is so much within even the survey circles, because then we are talking about the survey where you're talking about actuals, but also where we're also talking about an understanding of one thing, the actual measurements of land, but also what it means for relations on land, especially where we're finding enormous boundary disputes, where we're finding disagreements on land. Professor Msinguzi, this is an opportunity to hear from you with regard to fit for purpose land administration. How is it solving the landlord-tenant impasse, as explained by all the other panelists?
Thank you very much, Mr. Moderator. I realize I didn't introduce myself at the beginning. My name is Moses Msinguzi, and I work in Makerere University as the Dean of the School of the Built Environment, but I'm also Associate Professor of Geomatics. Maybe before I tackle that, I think I need to mention that one, in many land discussions, you'll never get a consensus, and it is normal. So even when we don't get any consensus, please, we shouldn't feel bad. The reason is that land is the domain for everybody. Politicians are there, lawyers are there, surveyors are there, economists, we have culturalists, social scientists, investors, and each one has a different perspective of land and how it should be organized. So with such diversity, I think we can accept to agree, but in our own different diversities. Maybe what I should also mention is that what should inform our actions on land. We have what we call a land management paradigm. Land management paradigm is a summary of what can be done on land. So it involves aspects of land tenure, land value, land use, and land development, all aimed at achieving sustainable development. So I also note that when we are discussing some of these things, we tend to put in sentiments, tribal sentiments, cultural sentiments, even emphasis on technology, emphasis on the economics, and so on. So I think this framework could guide us. Having said that, I would like to mention that I had prepared also a discussion document, but because of time, I will not go through the entire document. I will upload this document on my Facebook page. I also believe that the organizers of the conference will upload it on the conference website. But my first question was, is Milo tenure such a big problem to land investment in Uganda? And this actually is a motivation for our discussion. And in summary, my answer is yes, it is really such a big problem to investment. Then the second question was, why has Milo tenure persisted? Even with all these good things and bad things we are talking about, it has persisted and it is still persisting. One of the biggest dictators in history of Uganda is President Idi Amin Dada. It defeated him. And as you see, Dr. Batunji was saying that Milo was abolished in 1975 and then it was resurrected in 1995. But Madam Sarah Kurata will tell us whether actually there were no freeholds or leaseholds or Milo titles issued between 1975 and 1995. Under which law were those issued? Then another question was, can history be used to address the overlapping land rights problem. So my answer for why Milo has persisted, I think it's here in detail. Let's look at the character of the beneficiaries of Mailo tenure. Who are they? And is it possible actually to overnight dictate over them? Then, what are the solutions that have been provided? Because of time, I think you can access this in my documentation that I will upload. Then, can history be used to address the overlapping land rights problem? My answer is we can use history to get lessons, but then we shouldn't replicate history. You see, we have an injustice and we have many injustices. And we know from experience that it is very difficult to dislodge an injustice, more especially if the beneficiaries of the injustice are highly placed. In Africa, we have slave trade, we have colonialism. We've been talking about this, and these are very clear injustices. But nobody would actually say, you actually address the problem of slave trade. You address the problem of colonialism. And this is the same case that actually we are going to encounter as we try to solve the Milo problem. So, what should be the solution to Milo? Rather than replicating history, the best solution would be to take a pragmatic approach to addressing the impasse. But we can also borrow from history. A pragmatic approach considers what is available, what is possible, and what is acceptable. If we address those three, then probably we shall come up with the solution for Milo. However, as members have already observed, this requires gathering a lot of data and basing any decisions on the basis of the data collected. Dr. Nakai has mentioned that the provisions of the Constitution were based on the study. I think I've also read that study. And I note that actually the sample size was too biased and too narrow to have informed a national provision in the Constitution. So, when we discuss Milo, are we actually discussing from a knowledge point of view, or we are expressing our sentiments or sentiments of our neighboring communities or neighboring professional associations, and so on? Now, I will introduce in what we call the fit-for-purpose land administration, which could also fit into some of the solutions for addressing the impasse. Fit-for-purpose land administration basically is an approach to land administration that focuses on the purpose rather than on the standards and the complex procedures. Instead of using sophisticated equipment for mapping, preference is made to simple equipment. Instead of using complicated procedures for registration, preference is made to simple and flexible recordation techniques. Instead of going into the formal dispute resolution mechanism, preference is made to the alternative dispute resolution mechanism. Overall, the process becomes systematic, simpler, and cheaper to secure tenure rights for all without discrimination. Fit-for-purpose land administration is a new concept, and it has been mainly applied by poor countries who do not have enough financial muscle to address the problems of land tenure security. We have piloted this technique on Milo tenure in Mubende and Mitiana and Kasanda, but we have also piloted it in other parts of the country, including Nuoya, including Adjumani, including Kabare, including Chisoro. In Mityana and Mubende, we have actually dealt with more than 30,000 occupancy rights, which we documented. And we have got experiences which I'm going to list down. These are experiences specifically on the Mailo tenure. One, the issues between landlords and tenants are specific to each parcel. They are also specific to each combination of landlord and tenant. So, which means we need to identify them differently. In other words, there can never be a one-size-fits-all solution. You cannot say, let's share between landlord and tenant, or let's the landlord buy out the tenant, or let's have an occupancy. Then two, the occupancy, these bibanjas, the boundaries, they do not necessarily follow cadastral boundaries. In fact, we found some of the tenants actually who didn't know that their bibanjas were actually contained in maybe 1 or 2 milos or 3 milos in some cases. And this is important because when you are going to address this impasse, you need to know which landlord has which tenants. And also, we found out that whereas in some cases, landlords are very powerful and have threatened eviction of tenants, in other cases, tenants have chased away landlords to an extent that some landlords cannot dare step on their land. So some of the discussions, I think it's as if landlords are really very strong people and tenants are very marginalized people. But in reality, it could be the other way round. Whereas the majority of tenants accept that they occupy land belonging to the landlords, some tenants do not understand that they are supposed to pay usuru to landlords, and they do not see the role of landlords. In many cases, landlords do not have a proper record of their tenants in terms of the location of the land that they occupy, the size, and even the extent. And some tenants have taken advantage of this. You come with half an acre, then every year you keep on extending, and maybe by the end of 10 years, you have maybe 3 acres. The cadastral records, these are the records that define the parcels. They don't provide an accurate picture of the land on ground. There are so many errors and inconsistencies in the area, in the shape, and in the location. You can get records from the surveys and mapping department, but when you go on ground, you find that actually what you get from there is different in terms of shape and even location. So, correction of such errors is a mandatory precondition for addressing the landlord and tenant issues. So, what can fit-for-purpose land administration help? As I try to conclude, the fit-for-purpose land administration helps us to identify individual landlords and tenant issues, to quantify the amount of land and its location. One of the limitations of the land fund, which I also don't actually agree with, like Dr. Batunja said, land fund, who puts money in the land fund? This is a private affair between a landlord and a tenant. So why does government actually put in funds? And these are funds for everybody. These are public funds. This is taxpayers' money. So there should be a way of addressing this problem without actually recourse to public funds. Also, correcting the errors in the land registry and cadastral database. This could be dealt with using the fit for purpose. Identifying legal and legitimate rights. And also facilitating informed negotiation between landlords and tenants. And I wish to tell you that actually in Movenda and Mitiana, in the 30,000 persons that we have dealt with, landlords and tenants agreed, and we gave them documents that show such a recognition. So what is important is now next, either to get a certificate of occupancy, which does not have a lot of demands, or maybe to negotiate other terms. It's a cheap approach, and it may cost not more than $50 per parcel. And we also know that tenants are actually willing to pay this amount, but not all tenants. These are tenants who see a potential problem. But tenants who have never seen a landlord and who don't think that there is a landlord are actually not even willing to pay this $50. So in conclusion, I would say fit for purpose is a means for implementing the pragmatic approach to addressing the Milo impasse in Uganda. It helps you to understand the issues in detail and to localize the solution to the problem as it presents itself on the ground. Thank you so much.
Thank you so much, Professor Msinguzi. Sorry about the first introduction. Thank you so much. You've come up with a couple of issues that I felt were very dear to the discussion. You talked about the first questions you came up with. Is Milo such a big problem to investment in Uganda? Where you said yes. Why has it persisted? Then you talk about the character of the Milo tenure holders. That is something key we have to look at. You talked about the pragmatic approach, where we're dealing with the tenets of available, possible, and acceptable. And then you also talk about the experience working in Movenda and Mitiana and Kasanda, where you have done work around, I think, certificates of occupancy. Yeah, you've done work around certificates of occupancy, but also that you've looked at how the relations are. And then you finalize with fit for purpose is a means of implementing the pragmatic approach to Mailo Land Tenure. If you have any comments or something you have to add to that from the panelists, please go ahead and say something.
Thank you very much. I loved it when Dr. Nakai took us through the past attempts in fixing the impasse between landlords and tenants. And she showed us that always an attempt comes when there is a crisis. The Bataka movement and the Bataka rebellion caused the enactment of Busulu and Evujolo and fixing the money payable at $1 then, which was 10 shillings. When that money lost economic value, that's when Idi Amin woke up and said he's abolishing Milo land. And yes, Dr. Msinguzi, you are right, that abolishment was on paper, but Milo titles continued to be issued. It was not implementable because they woke up one day and there was nothing that the managers could do. But even then, even if he abolished it, still the landlords were holding this paper but not having any value. And in the 80s, an avenue came up. They started borrowing money from banks. Banks were accepting these titles and they were deliberately defaulting. Now, from 80s onwards, it was the banks which were evicting people because they would evict and sell. The one that became rampant, this constitution reinstates Mailo land and gives the tenants some security. And these people are supposed to pay an annual fee equivalent to the Busulu and the Mvujo. But still, as long as it does not have economic value, and yet the tenant is using this land for much economic gains, the landlords become impatient. You imagine a landlord putting up a tenant putting up a building as big as this or bigger and paying to the landlord 50,000 shillings per year. That does not make economic sense. It is important that this impasse is done in such a way that these overlapping rights are dealt away with once and for all. Fit for purpose would come in to document, and as Dr. Msinguzi said, there is no uniform formula for all parcels. Once documented, the landlord would know who his tenants are, and the tenants may know who the landlords are and which land is free, and then we see how or whether to apply the land fund. But yes, the land fund, Dr. Msinguzi, has been used in other jurisdictions. It was used in Ireland. They used it in Australia because this was brought out by the state. So the state takes a step further to see that it solves this problem. Thank you very much.
Thank you so much. Yes, Owechitiibwa Daudi Mpanga. And after the submission, we're going to go to the questions. I'll be letting you know what you can respond to as we use the last 45 minutes we have.
Excellent. And I hope I'll be permitted to look not just at Dr. Msinguzi's able submission, but also to mention a couple of others. I think it's now an open panel discussion. So first of all, if I may, regarding sentiment, I think we need to recognize that land is debated and discussed to this level because it's used by people. People are sentient beings, and of necessity we have sentiment. A story is told of an imam who used to preach to his flock. I don't know whether they're called that in the Islamic tradition. But the imam had followers whom he used to tell to desist from crying when they were bereaved, because of the belief that when you cry on the demise of your loved one, your tears prevent their ascent into heaven. So the imam, every time somebody died, would urge his followers not to cry because their tears were preventing the loved one from ascending to heaven. Unfortunately, the imam also lost a daughter, as time would have it. When the imam's daughter passed on, the imam started crying. When the imam cried, his followers said, "Imam, don't cry. Your tears are going to prevent your daughter from ascending to heaven." And the imam said in Uganda, "Today it's impossible for me not to cry." It's because the sentiment that we see in others we see it when we're detached from the emotion connected with a particular incident. We only see it when, to be sentiment, it becomes common sense when it applies to me. So, if I may, Doctor, and this is not by way of critique, but it's in order that we'll apply the right tools to determining these questions. The land where my forefathers are buried, where I hope to have, cultural realization of certain aspirations, etc., is very hard to discuss outside the context of sentiment, culture, call it what you like. And in fact, I think that if we build that into the discussion and enable people to understand that their aspiration, their sentiment, their feeling will be dispassionately considered, we get very much closer to the point that maybe Dr. Batunji was trying to drive. One of the difficulties in achieving uniform land tenure has been the fact that when you come to discussing land, people cease to speak in a completely dispassionate way. They look at it as, if you're removing Milo, I'm very sorry, but there's a hidden agenda behind that. And immediately their mind switches off. So, whether, and Dr. Nakai will forgive me for using her first name, a rose by any other name, as Shakespeare said, is still a rose. So we can abolish Milo and call it Jackson. We can abolish Milo and call it Juliet or Rose. If the issues that concern people if the perceived injustice or the perceived hidden agenda is not addressed, if the deficiencies I spoke about are not addressed, unfortunately, we will not achieve that thing which we look for. The substance is very important. The form is good, but the substance is, I think, far more important. And I'd also like to support Dr. Nakai when she says that it's therefore important that top-down approach, the uniform-driven approach, always leads to people seeing hidden agendas, leads to people perhaps being too dispassionate over what is essentially a passionate thing, and overlooking certain sentiments. And that causes failure. It will cause failure because people will see it as driven from somewhere else, not driven by their concerns. It will be driven in a way that believes that there's a uniform land use. For example, there isn't a uniform land use. So what look like empty, large ranges of empty land in Karamoja, to the Karamojong who is still in the traditional cattle pastoralism land use, that is very effective land for use and is a very effective land use. For the Muganda or somebody else who sees settled land use as the only land use, or the miner who may want to come and excavate the land to get marble, platinum, or whatever other mineral there is in Karamoja, what looks like, let's make this land tenure uniform in order that I may buy and use for purposes of mining or for purposes of commercial agriculture, settled commercial agriculture, is a complete violation of what the Karamojong understands land use to be. So we need to understand those things and use, I'm agreeing with Dr. Musinguzi here, data-driven and fit for purpose. Fit for purpose must be, in many ways, localized and brought into the demand of the population. It mustn't disempower people. And in disempowering people, again, landlords are people. They don't have tails and hooves, or they're not made in Britain. They're Ugandans. Some put their money in it, some expectation, some, whatever aspiration. So unless we ensure that we resolve these things, I think it's important. Very lastly, and again on Dr. Musinguzi's project, I'm really keen to read the full report and the pilot that they're running. It's really critical to ensure that we follow used templates, the templates that have been used before. For example, if you look at, as Dr. Batunji was also talking about it, an arrangement of 60-40 that has largely been driven by, say, compensation. When you're building roads, when you're building public utilities, a formula of distribution of that compensation has been set up and works in many places. It's worked, but why don't we use that as the template for the reform? You see, that's, I always wonder why we then try to go to utopian proposals when there are practical proposals that have worked. Fit for purpose is, I think, a very critical guide, should be a critical guide. It might be the name of the project, it's an appropriate name for the project. Let's find fit for purpose solutions to these things. We're not talking about, land on the moon. We're talking about land that people occupy. And those people are sentient beings. So to my mind, that would be my contribution. And very, very, very lastly, the politicization of all of this. Again, as Dr. Musinguzi said, politicians are amongst the people that live on the land. But politicians are also people who benefit from the votes of the people who are on the land. And so things can be subjected to and become populist-driven. Mr. Mwebe, if all of us voted on who should own your suit, you will not own that suit. But it's yours, you see. But there might be 4 of us here or 5 of us who actually want that suit and think that it would be better suited on us. We must find a way that just doesn't apply straight populism and weighing of numbers, but we must find a thing that resolves this problem once and for all in a sustainable way. Thank you.
Thank you so much, Wechitiwa Daudi Mpanga. Can we please have the questions so that then we can have our panelists respond to some of them? So we have some comments from the people that are online. I'll be putting them out. I'll be picking on someone who would respond to them. If Milo is the same as freehold, then why do we create freehold on Milo? Okay. Two, from Nabaterega, having a uniform tenure, where does this leave Buganda Kingdom? Wechitiwa, if we're talking about a uniform tenure, where does this leave the kingdom? Kukundakwe Anthony, can Milo land be converted to leasehold tenure? Okay. Timothy, there must be a search for bona fide pre-1900 landholders who were left out of the 1900 land allocations. They must be adequately compensated. And then after that, we can be at par. That is suggestion to deal with the injustice. Mike Obaguma asks, why is the basis of the 1900 Buganda Agreement? What? I think it's what is the basis. Didn't land and Buganda exist pre-1900? What was the arrangement then? How about the existing customary landowners in Bururi and other counties where land was given for free to chiefs, and most of whom didn't know the location of these lands? Ms. Sarah Kulata, that could go to you. Madame Sarah Kulata she said using the freehold tenure system, can you apply for freehold? Well, I please request the people who are writing out the questions to be very direct, because some of these questions are really winding, and the question gets lost in the writer. Uniform land tenure is important, but what we need to see is that even on your hands, not all fingers are equal, but serving the same purpose of handling what's placed in them. What we're talking about here is security. Okay, from Josephine. Josephine says, the national land policy gives clear options on how the impasse can be resolved, very much in line with some of Dr. Nathan's recommendations. What efforts has the state put in place to operationalize the national land policy options? Are we politicians, technocrats, etc., more impressed with or drawn to legislating and strategizing every now and then as opposed to implementing? Yeah, are there any efforts around implementing the provisions in the national land policy that deal with the Mailo Land Tenure? Are we so interested in reforms other than implementing what is already existing? That's a question from Josephine. Where has the state proactively supported owners and tenants to negotiate buyouts, sharing, leasing, etc.? What are the results of the land fund used by Uganda Land Commission? Where has it been used, and how much of it has benefited the people without political patronage? Have professionals proactively piloted the effective ways to realize the national land policy options away from profiting from the dilemma of owners and occupants? All these are from Daniel Kirumira. We don't have the benefit of having someone from the Ministry of Lands. All these questions would be going to the National Land Policy Secretariat. But if any of us can respond to this, it would be good to have responses. Question to the panel: why can't the government first seek consent from the landowners to see how many people are interested in the uniform land tenure, and let the government convince people that having a uniform tenure system is in good faith? Why can't the government first seek the consent of landowners? One of the panelists talked about consensus. Okay, from Kisa Benjamin. Okay, let's go to, from Don Binyina, says, Dr. Nakai, what's your position of government's policy on compulsorily acquiring land on behalf of investors based on the government's valuers' rates to the exclusion of landowners' rights to access private valuers, plus the denial of the right to access remedies by investment-affected landowners? That goes to Dr. Nakai. Okay. Just let me take two more to Dr. Nathan and Professor Msinguzi. How feasible could land consolidation and readjustment be leveraged to operationalize land value sharing between owners and occupants without exacerbating land fragmentation and disorderly land or rural development? How feasible could land consolidation and readjustment projects be leveraged to operationalize land value sharing between landowners and occupants? And lastly, to Dr. Nathan, the 1995 Constitution never provided for freehold to be the uniform land tenure in Uganda, not even the spirit of the Constitution. That's from Mr. Eddie Nsambagaiya. And lastly, to Council Mpanga, some of the issues raised by government is the frustration they have faced when acquiring land for investment, where some landowners refuse to surrender their land. What is your position with regard to compulsory land acquisition for public use or investment? Have the courts defined for us what would amount to public use in doing away with Article 26 under compulsory land acquisition? I'll leave that for now. I'll start with Dr. Nathan Batunji. You seem to have questions coming your way. I'll go to Dr. Nakai and to Dr. Msinguzi, and finally to OHT.
Thank you very much. I will start with this question of Nsambagaiya and illustrate it with the various sections of the Constitution. Our Constitution recommended 4 customary tenures, 4 tenures. And it also puts the ownership, supreme ownership of the land to the people, the owners. Now, the purpose of giving the land to the people was mainly because the people and Parliament, as it were already fed up with what they had seen out of the 1975 land decree of Amin, where government, which was in possession as the supreme owner of the land, decided to abuse that power and change to a new tenure system of leasehold without consulting them, without even any research as to whether leasehold would really hold. Because as we have seen, customary is held in perpetuity, Milo is held in perpetuity, freehold is held in perpetuity, and leasehold, which he recommended, is only held for a fixed time. And in Uganda, that was not really a big part. So to have jumped onto it angered many people. And that was one of the reasons why they moved and said, instead of giving our powers to government and they play with our hospitality, they removed the powers and took it back themselves. Why do I say they removed the powers? I started by saying that traditional owners, which is the first stage of ownership, traditional ownership all over the world, the people own their land. Now, when they moved to the second stage, where land was recorded, once government moved that stage and started recording the land during the feudal period, the feudal era, because of that 1975 problem, they decided to remove and put the lands back to the people. Now, what does that mean? It means that the people, having owned the land, they were now putting the aspect of perpetuity into perspective. But when you look at it, you realize that at that time when the Constitution was made of 1995, on paper or actually in actual aspect, we had a uniform tenure. Because once it is decreed and it goes on, and it is in all the books, you cannot wish it away. So how could they wish it away? So what was done was to replace it in that uniform aspect, to replace it with freehold. And the reason you can use to understand that it was replaced with freehold is because the same Constituent Assembly acknowledged customary tenure. But as soon as they acknowledged it, they realized that customary tenure has overlapping rights, which they did not want to encourage anymore, because this is what we are fighting. So they, in the same vein, acknowledged it, but also allowed it to convert to freehold. And that alone tells you how freehold now gets an edge and becomes a super customary tenure. But at the same time, Parliament realized that Uganda, all the regions of Uganda are not at the same level of development. You have Buganda region is highly developed. You have Western region. You have the Northern. Now you have the Central. Now all these are not at the same level. Therefore, they realize that educational literacy and also socio-economic development in Uganda was not at par in all the regions. So they said, if we now declare, although we already acknowledge that freehold is supreme because we have already allowed it to convert, even the other tenures in the Constitution were also changed to customary. Although we know that freehold is superior, we cannot allow it now. And it was in that vein that they put up this Article 237, Section 9, subsection B, to say that the incoming Constitution should ensure that both tenants and landlords acquire registrable interests. I want us to take a difference here, because registrable interests can only be given in the Ministry of Lands. That's where the registries are. But the certificates of customer ownership that Professor Msingz was talking about are issued elsewhere, not in the Ministry of Lands. They are issued by local government, I think, at the gombololas, by the, what they call them, the recorders. So you can see the Constitution was very clear. It was very clear. If you really are talking about land titles, which you can take the bank comfortably, go to the Ministry of Lands. But if you are talking about an administrative structure between the tenant and the landlord, you can do it at another level. That is at the local government level. And that is where we can say that, the declaring is what Nsambagaya sees, that it was not done openly. But in spirit, that was what it is. And that is the reason why customary, after being created, was allowed to be converted to freehold, because they didn't want to be seen to encourage overlapping rights. And in fact, overlapping rights is the problem that has been at the stage being fought. Amin fought it, didn't succeed. And during the NRM government in 1995, they wanted to fight it. It was a tough war. But as Mr. Mpanga has raised it, that when you talk about some of these things, people close their minds. They will close their minds, they may boycott. So these are type of fights that have been on. But even against that kind of background, still the Constituent Assembly was able to say, customary tenure, I have put a direction to make it freehold. Freehold is already okay. Leasehold is already okay. What was remaining now was still Milo, where people closed their minds and didn't want to hear anybody talk about it. But still, you see this Article 237, 9B, which says the Parliament should now go out and ensure that you give registrable rights. In other words, you don't do it at the recorder, you do it in the ministry. Use the existing registry systems. And this is where I was basing to say that the enabling laws, which is the Land Act and the land policy, they missed this instruction. There are certain, if you look at the land policy statement number 39, B, they are writing to say that a registry should be formed for customary land tenure. Now that is wrong, because customary tenure was already solved in the Constitution. It was not an issue. The only issue we have is Milo. Customary is done. So to put that in the land policy was a mistake to me. And that's why I'm saying that when you come to that aspect, we are only dealing with Milo, and we are looking for ways of doing it gradually. We don't want to fight anybody. Gradually. Let's involve the people to talk. But whatever little they do, we receive it. Thank you very much.
Wow.
Yeah, the beauty of this panel is that you can disagree on principle with your elders. And also, I've just realized that it's possible that the panelists have a diversity of analytical frameworks, because some of us are lawyers dealing with land, surveyors dealing with land, valuers. So sometimes it's difficult to agree. Just allow me to weigh in a little bit on this debate, because I really want the record to be straight. We need to draw a distinction between agendas and realities, especially on this question of freehold as a uniform tenure. It is not doubted that the long-term agenda is to achieve that, but we should pick the realities from the current law. Just to go a little bit back, we cannot discuss this question outside geopolitics and the role of some of these Bretton Woods institutions such as the World Bank. And of course, that means we need to ask ourselves, whose agenda are we promoting? Is it our agenda, or is it the agenda of those or those actors in geopolitics? I came across a book called The Mystery of Capital: Why Capitalism Triumphs in the West and Fails Everywhere Else, by somebody called Hernando de Soto. He was a darling of those institutions. He made an argument that the reason why we are poor is because we are not in position to transform our land into capital. It is dead capital. And the reason why we're not able to do that is because it's not registered. The World Bank did a study, I think it was called Land Tenure for Growth. They were promoting freehold and encouraging countries to convert customary tenure to freehold. And this is a time when Uganda was really debating land reforms. So we found ourselves a victim of these institutions. The World Bank funded the 1989 study that we talked about on agricultural development, from which that recommendation arose. So they started going around promoting this promotion of capital out of land by encouraging registration. We got the first drafts of the Land Act talking about or hiding that agenda in provisions that were intended to achieve it in slow motion. For example, the provisions he refers to, converting customary tenure into freehold. Now later, that gentleman got a lot of criticisms, and the bank did another study. In this study, they came to a conclusion that you should actually allow customary tenure to evolve into that tenure that can make a contribution to the market. You should not force it by conversion. Now, when that agenda came through, we were already stuck with the initial provisions of all customary tenure can be converted to freehold. And now we had to look back and ask ourselves, oops, what did we do? The general agenda of our givers has changed. As I speak now in the land policy, there is a provision saying that only individually owned customary tenure should be converted to freehold. This therefore means that the broader agenda that my senior colleague here is talking about is no longer the reality or is no longer the agenda in Uganda, because of the realization that if you allow a very traditional tenure to convert into freehold, you will cause trouble. If land has thousands of interests and you're converting it into freehold, giving someone exclusive rights, what is going to happen to all these other interests? In Meru, there was trouble because men that got registered in the process of conversion sold off the land and communities were left landless. So when I look at the land policy today, I can tell you that we are suffering from following the wave of those institutions. We are now going back to say, if you want and it is yours alone, you can convert it. Otherwise, we can no longer convert all customary tenure because of the catastrophe that might cause. And also, I would invite my colleagues that say that freehold is perpetual to look at Section 3, subsection 2A of the Land Act. Definitions are in the law. Section is very clear. It can be perpetual, it can be less than perpetual, it can have conditions. If you look at most of the titles that are issued to people who convert their customary land into freehold, it has conditions. It has conditions. And that is the law. So now I come to the questions that were put to me. Can you convert Milo land to leasehold? You can create a leasehold on Milo land. If you create a leasehold on Milo land, you'll be, I think, giving away your rights to the Milo land, because the two are basically different tenures. Milo is perpetual, leasehold is most times periodic. Somebody asked me a question about land acquisitions. My answer is all land acquisitions should abide by the Constitution, Article 26, which says compensation before acquisition unless the law changes. Or acquisition after compensation, sorry about that. But it is Article 26. There was another question about why not implement the provisions of the law. I agree, because I've been to quite a number of engagements where one of the most popular statements I have always picked about implementation of the Land Act is that implementation is in its infancy. I first heard this statement sometime in 2001. I heard it in 2006, 2014, 2015. Implementation is in its infancy. I wonder when implementation will ever grow, because it's very difficult to tell whether these initiatives are going to work without implementing them fully. Because if we implement them, you will know that they have either worked or they have failed, such that we look at other provisions. Then lastly, I just want to make a comment about land and politics. I was recently writing something about the politics of land law reform, and I came across very interesting pieces of literature. And one of them was written by somebody called Jimmy Anthony Okuku in a journal called Africa Development, and that piece was called The Land Act 1998 and Land Reform. Jimmy Anthony Okuku describes the politics leading up to the Land Act and makes very interesting observations. He first of all says that the Act came up at a time when there were quite a number of government programs that were competing with it. Bonabagagawere, Plan for Eradication of Poverty, all those acronyms. And then he later makes a very interesting argument about the fact that the reason why we have Milo land protected in the initial drafts of the Land Act was that Buganda Kingdom and the central government were intimate bedfellows, quote unquote. He makes reference, no, intimate bedfellows is not his word, it's my word, but just use it in that context. He talks about 1993, return of Ebyafe. He talks about the Constituent Assembly, and then somehow makes reference to the fact that when you look at the provision of Section 29 defining bona fide occupants, taking us back to 12 years before the passing of the 1995 Constitution, you will land in the early 80s after the Bush War. So he says that there were interests here that had to be consolidated and taken into a law. The kingdom got Ebyafe, and the people who had acquired land during that time would be defined as bona fide occupants entitled to protection. And then the result was a consensus. And then he goes ahead to make an argument that, in politics, when you're moving together, sometimes you can agree, other times you disagree, and then it comes to a point when there must be detours, as in you go right, I go left, or we move forward. So he makes that argument that it's very difficult to look at the reforms of the 1998 outside the context of political relationships between the centers of power when it comes to issues to do with Milo land. And there's another piece that is written by somebody, by Mabike, that somehow makes me think about whether there is any relationship between their argument and the current debates that we are having, especially in terms of the question of why the reforms, why now, about what, who is asking for them. So it looks like we cannot divide, reforms from the state of affairs in terms of political relationships, according to that literature that I have referred to by Jimmy Anthony Okuku.
And as we are saying, sometimes we technical people engage in our discussions, but obviously the politics have to affect what we discuss. Then there was something about land belongs to the people, which Dr. Nassan talked about. This idea of land belongs to the people, I think it was also one of the negotiations during the Constitution. And as you know, in Uganda, because of the diversity, more especially in terms of tribes, I think there is a general feeling that putting the land in the hands of government can really bring problems, because what is government? From history, each government actually has got a dominant section from probably one part of the country. And I think that could have also influenced, as I said, politics for deciding. And I've also seen actually in many countries where I've worked, where land belongs to government, on ground, actually, you find that land belongs to the people. I was in Mozambique 2 years ago, and in Mozambique, land on the paper belongs to the government. But when you go down now into the nitty-gritties, you find actually that land belongs to the people. And also, let me also ask you, even if land belongs to the people, you have certain laws, you have land use, you have physical planning, you have land acquisition. All these laws can really lead to your land being taken away by government. So I think this is a political statement in the Constitution that land belongs to the people. And also, as I mentioned, and also in agreement with Dr. Nakai, I think we can always disagree. My thinking was that in the Constitution, there is no deliberate, I think, preference for freehold. And when you go on ground, actually, there is customary. In customary, we have two types of customary, and we have worked on all types of customary. There is customary, which is predominantly communal, mainly in northern Uganda and eastern Uganda. And there is customary that is predominantly individual. This customary that is predominantly individual actually can be called freehold. The only difference is that it has not been brought to the register. So we can maintain customary, and as Dr. Nakai has said, Originally, the thinking of World Bank and other international agencies, including UN, was that land should only be recognized as freehold. But over time, I think there was a realization that the problems on customary are not necessarily to do with the system of holding land. So that's how the concept of accepting, registering customary the way it is came up. And I think that's what World Bank is promoting. And also, Dr. Nakai, I would like to somehow differ from you. I think in many cases, World Bank does not influence so much what you do in your country. I say this on the experience that I've had working with World Bank in some countries, including actually here in Uganda. When you are very sure and you have built consensus about how you want to manage your land, I think World Bank will not disagree with you. For example, when World Bank came, the Ministry of Land, Housing and Urban Development, I think Madam Sarah will agree with me, the preference for the titles was freehold, and actually many titles were issued. But I think World Bank is now also moving to customary. They are saying, okay, if customary is a recognized way of holding land, then we can support it. There were two more questions which I'm going to summarize. There was one about land consolidation and readjustment on Milo, whether actually this is possible and whether it is not going to contribute to land fragmentation. Here, we are dealing with a problem of overlapping tenure rights. But there is also another problem of land fragmentation. And this is a big problem, whether it is on Milo, whether it is on freehold, whether it is on customary. And for the areas where we have worked, you see parcels, land sizes can even go up to 2 decimals, 3 decimals, and this is in the rural areas. And the president several times has insisted or advised that people should not further subdivide land. Maybe land should be held at the family level. So that means we actually seem to be going back to the communal ownership that is in northern Uganda and eastern Uganda. So I think on Milo, maybe as we also look at separating these rights, we should also look at land fragmentation, not only on Milo, but as a countrywide program. Finally, there was a question on compensating people who were holding land before the 1900 agreement and so on and so forth. I discussed that in my presentation, and I have it, that we cannot look at history really to replicate history. Maybe it can give us lessons. Let's see what is pertaining now, what is possible. And what is good, there is a difference between what is good and what is possible. To me, I think let's pursue what is possible rather than actually looking at what is good. Thank you so much.
Thank you so much, Professor Msinguzi. OHTY, just your parting shot, because we've run out of time.
Thank you very much. As a parting shot, if I may start with Dr. Nakai's observation about implementation is in its infancy, reminded me of the fact that every time we speak of Uganda, which is 59 years old this week, we still hear it being described as a young democracy. So perhaps arising from it being a young democracy, implementation will always remain at infancy, whether 5 years, 10 years or so. But I think it brings out a very important point, that a lot of the concerns that we have about land administration, etc., are inextricably linked with our governance questions. When we talk about corruption, when we talk about deficiency in administration, when we talk about problems and deficiency in land adjudication, we're talking about governance. When we talk about why do reforms succeed or fail, we're talking about the legitimacy of governance. We're talking about how much faith, trust, acknowledgement, different people at different levels are willing to vest in the state as an arbiter of competing interests. So we cannot escape the issue of governance and the shortcomings that manifest in this infant democracy 59 years later, unfortunately may still persist, and therefore mean that a lot of the land reform that is recommended at whatever stage remains in its infancy at various stages. So again, look at the mediator that we were talking about. Look at the recorder. Look at the district land tribunal, etc. All those things in infancy we failed to achieve. I was asked a question about compulsory acquisition. I think it was sufficiently answered by the two preceding speakers. I need not go into that, but maybe let me add this, that again, the issue of state ownership of land as the panacea of reform, again takes us back into that question of governance and how much faith people will have in the state, and what is the state, and is it not also the construct of the colonial injustice that we talk about that feeds the whole narrative of 1900. My own parting shot would be that let's try the best we can to get as much data and information as we can. This has been a very useful, informed debate in my view, and it's the kind of debate that one would hope to replicate across. I didn't hear a single person calling another a name. I didn't hear any rude interruptions. I didn't see or hear any demonization of one's views or others. Let's understand, as Dr. Nakai was saying, that there are agendas. And these agendas might be native, they might be foreign, they might be a hybrid. But let's understand those agendas, analyze the agendas for what they are. And it's very important, especially when it comes to understanding from the native perspective, that whereas we need to get our land being productive, production doesn't mean getting it in order that when we give it to the Chinese or to the British or to whoever else is available. We must understand that getting land reform right doesn't mean that the older brother must be able to take it away from the sisters. I've dealt with land disputes, a whole spectrum of land disputes. Sorry, I made the annotation here. At an earlier point, I wanted to make the point that we talk about land disputation as if it's only between landlord and tenants. But we have Milo versus tenant, landowner versus tenant. We have Milo versus Milo, where we have overlapping Milo titles. We have Milo versus Milo, where we have neighborhood disputes. We have Milo versus Milo, where we have ownership disputes within families. We have Milo versus freehold, where we have freehold titles mapped over Milo titles. You might say we're now dealing with solving 1900, and you give Dowdy the title. Dowdy dispossesses Lydia, dispossesses Peter, dispossesses Katon. I'm talking about my siblings. I'm talking about my cousins. Then we have in Milo an understanding that a title held in my aunt's name, and I'm giving a real life example, might belong to my aunt as a custodian for all of us because that's where we're all buried. I have lodged a caveat when Madame Kulata was the registrar on that basis that somebody was threatening to sell the land where my ancestors are buried and where I hope to be buried. I might live in Australia, but that Milo title should not be sold just because there's one person who's the registrar, who's the registered title or holder. There's the same with clans, the same with sub-clans. So we can't just say that it's uniform land held in perpetuity. We must accept that there are interests that custom may understand, and that freehold has become, we call it Uganda waza. When you talk about the internet, there's a Luganda word for the internet now. Baganda never knew the internet. But Omutimbagano, exactly. But when you say it, you make it part of what is yours. So for better, for worse, this tenure system which came from abroad has now certain incidences which reflect who we are and how we live. So we need to have all those things taken into account and come up with something that is just, that looks like us, and that can help us all develop. Thank you.
Wow, thank you so much. there's a native agenda, there's a foreign agenda, but we could also be dealing with the hybrid agenda. So whatever the agenda is for the reforms, we need to open our eyes and be able to decipher what it is that's best for our country. This is time up for our public dialogue on the Milo Land question, which is organized by the Department of Geomatics and Land Management in Makerere University. We thank you all that have been here in person, but also those that came online. We thank the panel that we have here, Ms. Sarah Kulata, who's a land tenure legal expert. We have Dr. Nathan Batunji, who's a land tenure researcher. Thank you so much. We have OHT Wadaudi Mpanga, who's a Minister for Special Duties in the Kingdom of Buganda and is an advocate. We have Dr. Rose Nakai, who's a Senior Lecturer, School of Law. And we have Professor Musinguzi, who's an Associate Professor of Geomatics and Dean School of Built Environment. I'm Mwebe Kalibala, your moderator, and it's been great having you today. Thank you so much, and we call it an end. Thank you.